Hello, my name is Ariel Beatty, and I'm an attorney with Colorado Legal Services. Let's talk about the types of evidence you might present during your protection order hearing. First, your testimony is in itself a form of evidence. You should speak to the judge clearly and honestly. I recommend rereading your complaint several times before you go into your hearing. You may wish to tell the judge what happened in a chronological order, or you may wish to start with the most recent or most serious incident. Keep in mind that the judge has never heard the events before and doesn't know you or the other party, so you should provide some background and context to the judge. You may wish to call witnesses. Witnesses can testify to something they saw or heard that supports events listed in your complaint. Next, you will likely have digital evidence to present. For example, you may have a video that you would like to present or photographs. We'll discuss videos and recordings specifically in a moment. For photographs, text messages, emails, social media posts, messages, or other evidence that is commonly stored on your phone or laptop, please keep in mind that you should print out this evidence in order to present it or put it on a USB or CD. Otherwise, the judge may have to hold your device in evidence for up to 82 days. You should always have at least 3 copies of each exhibit, one for you, one for the judge, and one for the other side. Sometimes it is helpful to have a copy for your witness as well. For audio or video recording specifically, you must bring your own device to play the audio or video recording. The court will not allow you to play a recording on their equipment. You must also have a copy of the recording on a CD or USB and have a copy for both the court and other party. For any of this digital evidence, you should be prepared to authenticate the evidence, which means you must show that the evidence is genuine, and you should lay a foundation for the exhibit, which explains why and how the exhibit was obtained. Here's a good template to follow. What is the exhibit? For example, a photograph, text message, or bank statement. Who took the photo, video, screenshot, etc. For example, you might say, I took this photo, or I am the one who took this screenshot. When was the photo, text message, or other evidence taken or sent? Where was the photo taken? Has it been changed in any way? It is important to state that your evidence has not been changed significantly in any way and is a true representation of what you are trying to prove. Your testimony is the why of this equation. When the why is the evidence important to the judge, a good example might be a text message, audio recording, or photo that ties into an event you wrote about in your complaint. Evidence must be relevant to what the judge has to review. Once you have explained the basis for your evidence, you should ask the judge to enter your exhibit into evidence. The judge will ask the other side if they have an objection. An objection could be based on relevance, foundation, or another type of objection. Relevance is whether something is related to the issues in the case. Authentication and foundation are tied together. The questions above that we just went through go to identify the evidence and link together what the evidence is, how it was generated, and the likelihood that it has not been tampered with. Completeness goes to whether something is accurate. A good example of this is a partial text message conversation rather than the full conversation. Hearsay is something said by someone who is not in court, and the statement is meant to prove something. For example, my aunt says that her cousin saw him hit her. A non-hearsay statement would be, I saw him hit her. A letter written to the court by a witness would not be accepted. The witness would actually have to make the statement in the court. You may disagree with a testimony or exhibit from the other side. The objections above are reasons that you may wish to object. You should think more about what the judge needs to see. The judge is evaluating whether the events listed in your complaint are likely to be true and whether those events are likely to continue.